So thank you very much, Mr. Oluwole of Osaze-Uzzi, for taking the time to join me today. Thank you very much.
Thank you for having me.
Yeah, Mr. Oluwole of Osaze-Uzzi is a former director of voter education with the Independent National Electoral Commission, and is currently the Honorable Commissioner of Justice and Attorney General of Edo State. Once again, thank you for joining me. Now,
thank you for having me.
I know that we have some few issues to highlight, but I wanted us to start with the just concluded NBA conference, where you have presented a paper. But before we delve into your presentation at that conference, I wanted you to, the outgoing NBA executive. I wanted you to score what are the things that you thought they did well, and what are those things that you thought they could have done better?
Well, thank you. It's maybe a bit unfair for me to try to score them. I'll score them too high or a bit low, because the tenure kind of coincided with the last 1 year of my being Attorney General of Edo State. So I have looked carefully at what they have done. Well, if I'm really going to be fair, I'll say they've done fairly well under the circumstances. They did receive, especially the president received some knocks, especially with the reactions to the assessment of the performance of the president. But YC and his team have not been too political, and I think that's a good thing. I think it's a professional association, and as much as possible, focused on the welfare and issues concerning the association. But people feel that the NBA should be more active, should be more radical in its approach to issues, social issues, apart from justice issues. There's some debate about that, depending on where you stand on it. I think issues of the rule of law should be tackled, issues of independence of the judiciary should be tackled, and I think to the best of their ability, apart from the minor infighting, I think they did reasonably well. So we're looking forward to the new team that has just come on board today, and seeing what they can actually do differently and raise the standards of a bar. A lot of people felt that the bar has been on a trajectory, and it's still on that trajectory. I don't think since Austin Alege, since people like YC and people like Mr. Pata, I think it's been on a trajectory, and I think we're heading in the right direction.
If I would, just a follow-up question to that, if there's one area that you would want the new NBA president to, squarely focus on, what would that be?
Well, I think we've already started discussing this issue of the judiciary and its role in the democratic process. It's the new, coincidentally, we have a new Chief Justice of the country, and we also have a new president. And I assume that the name of the justice will be forwarded to the National Assembly of the Senate, and I believe the Senate will clear her. So it's we're at the precipice, we're at the point where things there's a rejuvenation, a regrowth, a rebirth, as it were. And both the president of the NBA and the Chief Justice of Nigeria have their work cut out for them. I think we should take a close look at the judiciary. We should look at how things are. In the last 12 months, things have not been so good. Perception of the judiciary, whether it's fair or it's not fair, especially with the decisions of the Supreme Court, especially with the Peter Obi case and Atiku case, the outcome of the presidential election, that's been quite controversial. And but in the eyes of some people, the judiciary seems to have redeemed itself with the recent case of what they call local government autonomy, which I participated in. But I worry for that judgment as a precedent. So we have to look at things. The interpretation given by the Supreme Court seems very populist, but I don't know, reading the clear wordings of the Constitution, whether it will set a good precedent when it comes to interpretation of the laws and of the Constitution, and where such judicial activism will take us to, I really don't know.
Okay. some other matters, popped up during that conference, and it has to do with a statement that was made by the EFCC chairman, where he had said that the EFCC was going to come after politicians, would come after lawyers who received corrupt money from people that the commission might perceive to be corrupt. I wanted to find out what you make of that kind of move by the EFCC.
Unfortunately, I was not there when at the session where the EFCC chairman spoke. I have just read about it from the newspapers and the media and social media. I don't know whether in any sense it was quoted out of context, so let me be very careful since I have not read the full statement he made. But I think this matter has been fairly well settled, that lawyers are not under the control of the EFCC. Lawyers are not financial institution for purposes of the EFCC Act and reporting of money laundering issues. In any case, it's difficult for a private lawyer to know where the funds for his services are coming from. We're not investigative bodies to ask our clients, say, look, where did you get this money from? Is it from your legitimate earnings, or is it from corrupt practices, or is it money laundering? I don't think lawyers are qualified to do that. Yes, there's an extent, there's know your clients or know your customers, it is for the banks, KYC, but in our case, know your clients. But it will be very unfair, and it will not be right. And the Court of Appeal, at least, has pronounced on this. Several high courts, and I think Court of Appeal, there was a case involving Professor Chief Osaze-Uzzi that has been decided. I thought that would have put aid to that. I'm not aware of any decision to the contrary. So I think he was out of tune. He may not have known of these decisions when he spoke the way he spoke, if he spoke as quoted by the media. And I think the lawyers have been up now to say, look, you are clearly wrong. So, and I tend to share the view that it probably was out of step if what is repeated to have said is actually what reported to have said is actually what he said.
But the EFCC, and you can correct me if I'm wrong, the EFCC boss is a lawyer. What do you think he was trying to, what message do you think he was trying to pass across, even if he was not aware of some of the laws that you have just quoted?
Well, I'm not in his mind, so it's difficult for me to judge what's from his face or his voice, what's the countenance, what the heart had in mind. But probably trying to sound a warning to lawyers, but lawyers are the last people you should warn, especially on issues of law. So he was with a take on the statutes, but they are eminently qualified people who have studied the statutes and who have a different opinion, a different view, backed by case law on that matter. Lawyers cannot be classified in such a way. And don't forget, we have the Legal Practitioners Act, which gives us some kind of protection in the sense that we are sworn to secrecy. The communication between a client and his lawyer are privileged, absolutely privileged. So that's statute. So we cannot go against. We have sworn to uphold Constitution. We have sworn to uphold every law, and it's against the ethics of our profession to go against any law, least of all the Legal Practitioners Act. So I really don't know what he was trying to say, but perhaps if it was that lawyers should be more circumspect, they should be more careful, they should help and join in the fight against corruption, I'll share that view with him. But there are other ways in which you could have communicated and solicited the cooperation of lawyers in that regard than come by way of threats or interpretations that are probably not correct.
I know we are here to, really focus on electoral reform, which was the paper you had presented, before your peers at the just concluded MBA conference. But because you wear too many caps, I just wanted to, ask you about, some developments in your state. And I know I don't want to put you on the spot, but I just wanted to, I know you would, as much as possible, try to, answer this as honestly as you possibly can. I wanted to find out the issue of the deputy governor in your state. As a lawyer, What exactly is your position on that?
Well, let me just quickly say, first of all, that I am a part to that state, to that case. Mr. Philip Shaibu, the erstwhile deputy governor, actually joined the Attorney General. So the Attorney General of Edo State was a defendant, and the Attorney General also appealed the judgment. So the Attorney General had an appeal pending in the Court of Appeal, and next month we'll go there for consideration of that matter. So I am not allowed by ethics of the profession to discuss the merits or demerits of the case. But we think our position, and by the way, I do represent, as I stand as counsel to the Chief Judge in that matter. My understanding and the facts available to me, the House of Assembly was scrupulous and looked at everything and was scrupulous in its consideration of every step taken. And it's important to note that Mr. Philip Shaibu actually partook in the hearing of the allegations against him. He had a senior advocate of Nigeria who was there, but for reasons best known to him, he later on withdrew his representation, but he already heard, and I think they closely followed that. The High Court seemed to have taken a different view and said it was not wrong. Our own contention was that the judge, who is not allowed to sit as an appeal court over the panel, in his own decision, seemed to have sat as an appeal and saying what constituted gross misconduct. The Supreme Court, the courts have held that it's up to the House of Assembly to determine what actually is gross misconduct. It's not an objective view. It's not something that we should speak about. It's not something that the courts will look at. It is what they see as gross misconduct that amounts to gross misconduct under the Constitution. The discretion is theirs. And also that there's an ouster clause in the Constitution basically saying that the outcome of this cannot be challenged in any court of law. So that is what we have before the Court of Appeal. We think that the decision is not correct and being dissatisfied. Several of the parties have appealed to the Court of Appeal. The case is now pending for the Court of Appeal. Yes, we believe it was scrupulous. And the interesting thing about that was that it was the office of the Deputy Governor that sued. And the office of the Deputy Governor cannot sue for an impeachment. Impeachment is personal. It's not to an office. You, Philip Shaibu, your complaint was against you yourself as a person and not in your position as Deputy Governor. You are complaining that I, Philip, was wrongly removed as the Deputy Governor of Edo State. That's his contention. But he sued as the office of Deputy Governor. The Deputy Governor cannot sustain such a case. It's our own idea and contention. And these are some of the issues we'll trash out when we get to the Court of Appeal.
Okay, thank you. Another issue, just a quick one, is I wanted your position on the Supreme Court's decision that the federal government pay local government funds directly to local governments. I wanted to find out what your position is on that.
Well, the Honorable Attorney General of the Federation sued me, the Attorney General of Edo State, and also sued all 36 attorneys general on behalf of states. We raised preliminary objections and we contended that the Supreme Court did not have jurisdiction. It could not exercise original jurisdiction to get that matter. And in any case, it has settled that matter. Don't forget that several years ago, the Attorney General of Lagos State took the Attorney General of Federation to court. Then President Obasanjo was president of Nigeria, and the current incumbent president was the governor of Lagos State. That case, Lagos State against Federation, has not been overruled. It was not overruled now. And basically says under any guise that there is no way that funds due to the state, to local government be paid to any other person but through the states as established by the Constitution. As far as we're concerned, the Constitution was very clear on that point. And it says there shall be established an account known as state local government joint account. It's there, it's still there in the Constitution. It will appear that the Supreme Court was in its interpretative role, and the issue is are they fallible because they are final, or they are final? So that makes them infallible. They have given their judgment. We are all bound by that, and there are practical issues to the enforcement of that judgment. Serious practical issues. Some states, including mine, those states, have set up a committee to see how we can best approach this transition, how we can best comply with the judgment of the court, because the Supreme Court, it has given its judgment, it's final, and there's nothing we can do about that. But as I said, the court did not, and by the way, it's a majority, not a unanimous decision. The court did not overrule. So that law is still that case law is still in a law reports, and so is this one. So it will appear the two conflicting decisions on the subject matter now. We hope that in the near future that can be taken again before the Supreme Court, so the Supreme Court can now look at both, examine both. The case of Attorney General of Lagos State against Petrol was cited to the my laws, but they had the majority had a different view. I also cited the case of Attorney General of Bauchi State against the General Federation, which says when it has to do with such revenues that the courts cannot exercise original jurisdiction under Section 251 of the Constitution, that is the subject matter exclusively given to the Federal High Court. So, but this was not considered, was not mentioned or referred to in the majority judgment, and they felt that we're bound by it. They can actually go. And don't forget that we submitted that for you to overrule a previous decision such as this, you have to expressly ask for it. We raised that issue, but the courts did not consider it. But now we are bound by what the Supreme Court has done. We now have to go to practical issues. Some states like Lagos State, like Edo State, did not already. They have elected representatives in place. The governors and the chairman and councillors, chairman of all 18 local governments in the states and all the councils are elected. So we're democratically elected. So we have complied with the Constitution. Several states complied with the Constitution. Some states said no, we can't comply because there are injunctions. At least 2-3 states, like Anambra, I think, there are injunctions against our conduct of elections. So it will be going contrary to these injunctions and contrary to the rule of law. If we contravene these elections, these injunctions, go ahead to conduct elections. So that's a challenge. Some other states, I think Kebbi and one or two, I said, the security situation in Atlanta will not permit us, will not allow us, will be exposing our staff, our officials, and the voters to danger because of the security situation in our respective states. So because of that, we don't think we can at this time conduct it. But those things were considered. The Supreme Court has given its verdict. Now, those states that don't have elected representatives now have to go. The Constitution said they will not go, they cannot get money unless and until they have now gotten elected representatives. Now, don't forget that the provisions of any conduct of elections are similar to what should happen in the area council of the FCT. That is part of the Electoral Act. The local governments are bound by the provisions, the CX are bound by the provisions of the Electoral Act in terms of procedure for conduct of elections. Now, the Electoral Act says there should be 360 days. That's almost 1 year notice given, minimum 1 year notice given for the conduct of elections. So any state preparing now has to give that 360 days notice. So what it means, basically, if you take things literally, is that the funds for those local governments will be withheld from the local governments and the states. So for the next 1 year, all those people who are dependent, like who are employed by the Local Government Service Commission, are not likely to get paid because monies will not be released for that. Teachers will not get paid. Teachers in the primary systems. Those who work in primary health care, some states have contributions by the state government and local government. That means they're not likely to have that. These are some practical issues, and that's why the federal government has set up a committee to look at how we're going to enforce that judgment. And some states, including Edo, have set up their own committees to ensure that it's done. These are some of the practical issues and fallouts of that judgment that have to be looked into. And it's a dicey situation, quite honestly, but I think we'll overcome it.
Okay, so if I hear you very correctly now, you've highlighted, some of why this thing is not going to be practicable. But before this judgment, how was the state administering local government administration in your state?
Good. I am happy you limited it to my state. Now, in accordance with this constitution, it's going to say clearly, funds due to the local government shall be paid into an account known as the Edo State Local Government Joint Account. So we opened that account, but it was being operated by the local governments themselves. The funds going to local, we are given to the local governments. In fact, I digress for a couple of seconds. The state government supports the local government in achieving all it can do, because local governments, both from the federal allocation and the IGR, cannot. It's difficult for them to cope. It's not sufficient funds. So very often states support these local governments. And don't forget, local governments are not a federating unit. There are only two federating units in our constitution. That is the federal government and in the state government. State governments, therefore, as to where issues with the states deal with local governments. But in any case, in our own case, we set up this account. The governor, who's represented by the Commissioner for Local Governments, now oversees this distribution of the funds due. The state government does not take any. What it does is that the joint account, now first line charge, you pay the teachers, you pay the medical personnel in primary healthcare systems, you pay pensioners. And we have been owing, there's legacy debts being owed to pensioners, and the government of Governor Basque has cleared most of those debts, but we're still, because it's such a humongous sum, we've been paying them by bits, so we've almost cleared the whole thing now. So we pay these things to us almost as a first line charge. Let us make these payments, and then the others are released by the local government, who take it to their accounts and do as they please with that. So that's the committee set up between the local governments and the state government to sit down and work things out, and then they operate those accounts and sign off on them. They operate those accounts just like the fact the state government commissioners for finance go to federation every month, sit down with the minister of finance and sort out what is due to states and the spread. That's exactly what we have been doing in Edo State. Some states have used that. It's possible that some other states have not used that system and probably have dipped their hands into the coffers of the local governments. Maybe that's why the Supreme Court, and I think Supreme Court said so. Supreme Court had previously said, and we all agree with that, that the Constitution requires that local governments, the representative local governments, should be democratically elected. So many Supreme Court decisions on that. So there's nothing new in that regard. But this time it went one step forward and said that, contrary to its previous decision, that they must be paid directly, and which we believe. If you go back, sit down, read the Constitution, it's well, but in their interpretative role, they have interpreted to contrary to the plain and ordinary language of the Constitution. So that's where we're at.
Okay, let's now take a deep dive into what you have presented before the MBA. Can you give me I know what you presented was about electoral reform, which was what influenced my, decision to invite you to let's talk about it. Can you give me a summary of what your presentation at that conference was?
Well, I talked generally and very broadly about electoral reform, starting with the historic perspective, and I referred to all the panels, the FEDECO panel, which was chaired by Justice Babalakin of the Supreme Court. We talked about those perspectives. Then the Ways panel, 40 years ago, 1984 was the panel set up by Justice Babalakin, by General Buhari when he was head of state, military head of state. So after the Babalakin report came the Ways panel, that was in 2007, 2008, set up by Musa Yar'Adua. Then the Lemu panel, following the disturbances in the post-election violence in some parts of the country. There was the Lemu panel that was set up. And then there was also, last but not least, was Namani panel set up by Buhari again as a civilian president. These panels also submitted reports. The Namani panel not only submitted reports, but gave some draft laws suggesting reforms, and actually drafted some bills for the Constitution. These bills were presented to the National Assembly. So also the Ways panel had also done a lot of that, drafted bills and made serious recommendations about the appointment of the INEC chairman and commissioners, and gave something. I agree with most of what they said. In appointments, I have digressed a little bit, but we talked about that and talked about what happened, the introduction of technology. So we traced it and said, look, when the smart card reader was introduced, people thought that was a game changer, and it probably was. But you see, it was not in the Electoral Act. And that's one of the things I raised in my paper, that look, the Electoral Act is basically not a digital act. It's an act based on the analog, manual act, but in its processes, its journey, its process and procedures. But that's the act of 2010. So in 2022, we now try to build on that analog foundation. We try to build a digital skyscraper, in the sense that we now introduce technology, but without uprooting some of those foundations and redigging some of those foundations. That's where we ran into problems. So in 2010, by the time we came and brought the card reader, the Act said prescribe a way and say, when you come for accreditation, you come, you bring your voters card, you look at your voters card, and then like that, the manual process. But in the guidelines, INEC went ahead and tried to get smart card reader game changer, tried to get more technology to authenticate the voter and stuff like that. But when those cases, the tribunal agreed with the petitioners that, look, no, you must read the card reader. Once card reader was not used, sorry. And the Court of Appeal in most decisions agreed with them. But by the time Mr. Wike against Peterside went to the Supreme Court, people said, no, these things are in the guidelines. As desirable as they may be, they're not binding because they're in the guidelines, and guidelines cannot supersede the Electoral Act. The statute was given to us by elected members of the National Assembly. They have the constitutional role to make laws. We, Commission, INEC can make subsidiary laws, but where there's a conflict or where it contradicts the Electoral Act, then those guidelines are inoperative and ineffectual and null and void to the extent of those inconsistencies. So that's what really happened in that case. So when we studied those judgments, now went back, INEC guy still was there, sat down with the National Assembly members, and we now said, look, let us reform these laws, let us introduce more technology, this game changer. And by that time, we said, okay, although the term smart card reader was used in the new electoral of 2022, we said, okay, but let us also use the sprays or any other technological device, because INEC had gone beyond the smart card reader and had brought the beavers by model voter of the series, and it's service. It had gone way beyond that. The beavers could do a lot more than smart card reader could. It can do all that smart card reader could do, but has done more. Now, some of these things I said, look, apart from using it to accredit people, you use it, you scan the ECHA, which is the result sheet, you scan it and upload it to the IREF, the results viewing portal. When you look at that, so anybody anywhere can look at, it's not a question of, oh, we voted, the results in my polling unit showed that Party A got 100, Party B got 5. It changes overnight before it gets to the collation center. So that was a wonderful idea. It was used in Edo, it was used in Ondo, the Edo governorship election of 2020, and people appreciated that. There were lots of downloads, people registered to use the IREF portal to see things. So people expected that, and INEC and its officials assured Nigerians that, look, we will replicate what happened in Edo, what happened in Kiti, what happened in Osun. These were used as trials. And don't forget, the first time the thing was challenged was actually in the Osun election, the case of Oyetola, Adeleke and Oyetola. And unfortunately, the Supreme Court said, look, to prove overvoting, you have to bring the card, the beavers machine, you have to bring the result sheet, and you also have to bring the voters register. So what we thought was entrenched in the Electoral Act. By the time the case of Obi against INEC and Atiku Abubakar challenging the victory of the APC in presidential election, the interpretation was given a much narrower perspective. And they said, no, it's a desirable thing, it's a good thing, but basically we still have a manual coalition process. So we now said, look, having traced this, these are the issues and challenges. In reform, what are we going to do? My own position is that you give the electoral, let it be a framework and just give very broad powers and certain guarantees, but all the processes leave to the Commission, leave to INEC, so that INEC will fill those guidelines, and the step-by-step processes and procedures will be done by INEC guidelines, and then it will entrench the technology and less human interference. We all agree that technology can be a game changer, but it's not a silver bullet. The operators can still abuse the system. We have seen that happen in several places. So we discussed that, and we discussed other things. My paper also looked at the issue of how the courts have interpreted several other things, like I've discussed about voting. We talked about burden of proof. The Evidence Act says he who asserts, he who claims this thing is like this, has the burden to prove it. And in the Electoral Act, INEC is a mandatory responding to all petitions. If you don't add INEC that petition will fail, bound to fail. So is it time to start looking at what's INEC be? If I accuse my opponent that is not qualified, he doesn't have the requisite qualification in terms of education, for example, why should INEC be a part of that? So the lawyers say it's a usem generis. It's different from, it's neither criminal nor is it civil. So why should the laws of evidence and the evidence apply to it? Should it apply to it? Is it not time we looked at it and said, look, in some countries like the Maghreb countries, you have their own electoral management body is not a mandatory party. In fact, it comes and it has the duty. The onus is on it to prove that it complied with the laws, the regulations, and the constitution in the conduct of elections. So maybe we need a new thinking. Maybe it's once the election is conducted, you come back and say, INEC, come and show us how you complied. And then the other party might say, no, I challenge you and cross-examine and bring evidence to show that contrary to what you are saying, you do not comply with this or that or that. So the burden, people argue that the burden should shift. And don't forget, you say bring the beavers, bring this material, bring that material. A lot of those materials are in custody of INEC. And sometimes INEC is slow in releasing those materials to affected people. And don't forget, you have 21 days for most, whether it's a state assembly petition or it's involving maybe.
Sorry, before you go on,
yes.
Why do you think INEC is oftentimes reluctant to release those materials?
Well, there are several reasons for that. Sometimes the bureaucracy catches up with you. You don't get the order on time, or you have to escalate it. Sometimes it's almost impossible to do that. For example, when you say you bring all the materials, a state assembly election, that's straightforward enough, it's small. But when you say presidential election, you have to bring materials from 36 states. The vastness, you've conducted elections in 150-something thousand polling units. You have to gather those materials, secure them, and then start transporting usually to a central location. The logistics of that can take more than a week or two. And don't forget, this will have 21 days to file their petition and to front load. That's another thing. They have to front load. Front loading means basically that every witness, you have to list every witness you're going to call. Not only do you list them, they have to give a written statement on oath. So you have to gather all your witnesses and let them have their written statement on oath. Also, the burden of proof also means that if you plead malpractice in half of the polling units of the country, that would be more than 76,000 polling units. You now have to get witnesses from each and every polling unit. That's a Herculean task. So it's weighted against petitioners. It's weighted against people who have been outdone by and who were out. These are some of the challenges. So we talked about Electoral Offences Commission. Is it time in our reform? We talked just as Namani suggested a similar commission. Solid waste. Is it about time to get one commission modeled in the line of the ICPC or the EFCC, but this time dealing with electoral offences? They should have powers of arrest, powers to investigate, and powers to prosecute. Now, INEC prosecutes, but INEC has no investigative powers. And sometimes it's faced with dealing with its own staff who are complicit in electoral malpractice. Will the political will be there, and how will that people feel when you say, it's INEC prosecuting INEC? And then you talked about gathering these materials, like the card reader. Don't forget the presidential and national assembly elections were held first. Now, there might be petitions by presidential candidates. There were in last year, 2023. But some people in the Senate and House of Reps also have petitions. It's the same candidate that was used for that election. So how are you going to divide that candidate? And that candidate has to be reconfigured. The beavers, I beg your pardon, has to be reconfigured for the next state house of assembly and governorship elections. This is the same machines we have to reconfigure. So there's a challenge in bringing all those things and not tampering with those equipment in that period. The voters register, the same thing. When you take the voters register for the presidential, you take for the national assembly, you have a problem where you take. But 2 weeks later, you have to come back and conduct the state assembly election. So if you're asking for the voters register, you're in a bind. These are some of the challenges and issues. That's when you ask me that why don't they comply with this next. And again, sometimes you have to sort out huge volumes of paperwork, huge volumes of materials that you have to and conflicting. There might be 5 petitions regarding the same election, so you have to satisfy all 5 people. And there might be, as I said, in the presidential, there are 3 elections conducted in one day, 3 different sets of petitioners or 3 different sets of people will be requesting for sometimes the same information, the same data, and to inspect the same documents. These are just some of the challenges.
Okay, so in 3 years' time, the nation will be going into another national election. I wanted to ask, from your experience, what would you consider as the most important electoral reform that Nigeria needs as we, prepare for?
Well, that's quite easy. But what I can do is in 3 years, I don't think so. It will take a generation, and that is a reform of the mind, reform of the citizen, the players, reform of moral reform. So you have to reform those who are involved in the thing: the judiciary, the lawyers, the voters, the candidates, the political parties. No matter how, it's not like a perfect law. Our laws, quite honestly, are incredibly good, incredibly, if I may say so. Because if you look at a country like most European countries, elections are conducted not by an independent management body. They have electoral commission in the UK, for example, but it does not conduct elections. It just sets regulations and guidelines, especially financial. The elections are conducted by the local governments, the local government councils, council workers. So with this trust in the system, in Scandinavia is the same thing. In America, it's conducted, each state has its own basic way of conducting elections. So even the presidential election is conducted by state governments. So you had one of the Bush brothers as governor of Florida during the Al Gore and Bush election. And Florida was deciding states, even though Al Gore won the popular vote, but the electoral college belonged to somebody, George Bush II. Now, sometimes the lieutenant governor, the secretary of state, who conducts the elections in those states, and these are appointees of the incumbent governor. You cannot have that in Nigeria. There's sufficient trust in the system. So basically, there's a desperation especially amongst the political class. We have to change our mindset. We have to change our reorientation. So even if the laws were weak, we could compensate for strong systems. But even with strong laws, if you have people who want to subvert the system, you're going to have that. Violence has no place. The people that will try and subvert the will of people, the political parties, the candidates, their supporters, sometimes the voters, you give them money and they vote one way and they vote the other way. So everybody has their own. Then the judiciary, the lawyers who take certain cases support, and the judiciary giving certain judgments. These are all issues that no matter how perfect a law is, it has to be interpreted, and the players and stakeholders have to operate the law. If you operate within the law, you operate with the feeling and the notion that the people in democracy are sovereign, and it's their wishes that determine who governs them. If we have that and live by that ethos, then we should not have any problem.
What do you think that stakeholders can do to strengthen the Electoral Violence Commission? I thought there was a commission like that where it was agreed that if you allowed yourself to be used by politicians during an election and you are caught, you face the music. But elections come and elections go. We see people, violate the laws, protecting the elections, and nothing happens to them.
Yes, indeed. Impunity is one of the greatest challenges that we face. You don't reward bad behavior, you punish bad behavior. But if you don't punish and give it an equal measure of punishment, then the chances are that these things will continue. There will be repeat offenders, and people will continue to breach and subvert the laws. So that's it, basically. You're quite right. But there are many issues with that. One, because we don't have a commission such as that, and we hope that this assembly will take the bull by the horn and pass that law that their predecessors have not done. And establishing INEC has been at the forefront of calls for the establishment of such a commission. So an independent commission, that is necessary, and make examples of certain people who breach the laws, the penal laws, and penalize them. I think that is so critical, and we should make a lot of noise about it. And I think we've taken some tentative steps. Mike Guinea, the former resident commissioner in Akwa Ibom and several other states, was at that conference, was at our session, he spoke about it. And we recall that a professor from the Akwa Ibom has been in jail, was jailed for malpractices. So you have, those are so few and far between. I know he has appealed. We'll wait to see what the appeal court says, but he's been given a term of imprisonment, and that's a big fish. In terms of money and corruption, and people call it vote buying. It's not vote buying. I keep saying that. It is voter inducement, bribery. That's what it is. When you say vote buying, it sounds seductive. It doesn't sound like an offense.
Is it not the case of potato?
Well, no, it's more than that, because first of all, the law does not say vote buying. It's not vote buying. You make it sound legitimate. It's just almost like saying you're buying tomatoes or onions in the marketplace. It is voter inducement, bribery. Vote buying is bribery. It's not just buying votes. You're bribing the voters. Now, I'm sure some people have seen it happening on social media. People say, I sold my vote. I got 5,000 for my vote. So they don't see anything wrong. Don't see anything morally wrong there. But if you say you have bribed 5,000 for your vote for 4 years, now I think most people find that reprehensible. and they will not boast about it. It's a thing of shame. We know there's hunger in the land, but there's still pride in people. It's a thing of shame, and I don't think that people will be happy to go about saying, "Oh, I was bribed." No. So, but the most difficult thing is, I would say, the wholesalers, those who bring the bulk money. We should try and see how we can get to those people, not necessarily the retailers, the small fry. The big fry are people who budget money and who now move these funds, huge volumes of funds. Because, for example, to bribe INEC officials, there are 3 or 4 people manning each polling unit. Now, that is more than 600,000. On election day, INEC commits almost a million people. Now, that's a huge amount of money that will bribe the majority of them. So these things come from sources. They come from there. And that's why I think INEC was cooperating and collaborating with EFCC. The fruits of that, I really don't know. I lived there quite a number of years ago, so I don't know what they have done in that regards. So yes, that commission will definitely help with investigative powers and powers also, prosecutorial powers to prosecute those who run foul of the law. It's a good starting point.
What do you say to those who say appeals on pre-election matters? National Assembly and State of Assembly should terminate at the Court of Appeal.
Well, we've tried that before, haven't we? We've tried that before. Recall that governorship petitions ended up in the Court of Appeal, but we have seen the results. Don't forget, State Assembly and National Assembly petitions still terminate at the Court of Appeal. But you had the problem in Plateau State, for example, where the judgments were given in one way, and by the time the governorship went to the Supreme Court, the Supreme Court overturned and upheld the judgment of the governor of Plateau State. And those people who in the National and State Assembly felt very, very aggrieved. The PDP candidates felt very, very aggrieved, because what it meant was that the Court of Appeal was wrong in its decision, but today they're out of office based on that erroneous decision of the Court of Appeal. So there are lots of conflicting decisions. There are lots of challenges arising from the when almost all of the presidential terminated in the Court of Appeal. So we've tried, it hasn't worked so well. But and that's one of the issues we discussed as well. Is it not time we probably go back and revisit this issue of the Constitutional Court? Maybe there should be a special court, because each time I heard the reports from some scholarly lawyers, Professor Chukwu, Professor Dikalo, and a couple of others, and they said that look, 30% of the cases in the last 1 year are election-related, are political cases going to the Supreme Court. That is a very worrisome thing. And those judges who served in tribunals, their courts were moribund for that period, for more than 6 months. So in the last 12 months, not much has been done in terms of other pressing cases, murder cases, kidnapping cases, rape cases, cases of high commercial value, and things that have suffered as a result of, because the election cases and cases are time-bound, they are given priority. So most courts have been just busy doing that. And when they take judges to tribunals outside of their states, their normal duty, the normal jobs, the judges don't attend to those things. So for 6 months, quite a number of judges did not sit. Court of Appeal was saturated, and the Supreme Court had 10, 12, 15 pre-election cases, petitions that we had to deal with. So maybe it's time, and this is part of the reforms we're looking at, maybe it's time we set up special courts or a constitutional court where appeals from tribunals go to that constitutional court and it terminates there. So that's one of the ideas that's being put forward, and I'm looking forward to communicate from the Nigerian Bar Association and also communicate from other conferences that we held dealing and discuss electoral reforms.
On quickly, as we wind down, on voter identification, with the introduction of BVAS, do you think INEC should now begin to permit other acceptable legal means of identification other than the permanent voters card?
Well, that's a good question you've asked. Except we amend the law, that cannot be possible. But that issue was raised. I had a very scholarly panel and other co-discussants and who presented papers. Samson Itodo of Yaga, who's in the forefront of reform, made that suggestions, which quite a number of the other my colleagues on the panel had 2 senior advocates. So Woni Koko is senior advocate, and also Sule, another senior advocate. And we all more or less were in agreement with that yes, it's important that When you have the beavers has in it basically the register. And then you should be able to come with your passport, your driver's license, or any other means of identification. Because in any case, with your biometrics there, all you have to do is put your thumb or your fingerprints is to identify and say whether you're the person, and your photograph will come up. So yes, we probably will get to that point. Absolutely. Once that business technology is improved upon, you may not need, and the need for your permanent voters card might not be necessary anymore. Any means of identification, even if you don't have identification, you come and imputed your biometrics, then it should pick it up and say you are eligible to vote. So yes, that's the question. Probably are very close to that now. Yes.
Last question. As we approach the next national election, I wanted to get your view on how INEC can begin to build the trust that it lost in some section of the country in the last election. How can they begin to build trust in the system again?
You know how trust is. It's a very delicate thing. Once it's broken, it's so difficult to rebuild. But it must do so. We don't have any other electoral management body, so we must have an electoral management that will conduct elections. So it's imperative that trust be rebuilt. It should take those first tentative steps to rebuild those trust, because it's a serious trust deficit. People don't trust INEC. It got so bad that I saw on social media people burning their PVCs. At what point our votes don't count? Doesn't matter. So there's a bit of despondency, especially after the 2023 general elections. But one of the quickest and easiest ways is to conduct a good elections. In 3 weeks' time, INEC is going to face a test. They are coming to Edo to conduct a governorship election. Don't forget, in 2020, they conducted a very good election, but people were still disappointed, or quite a number of people were still disappointed. Although when you really look at it, in certain ways, in certain contexts, that is one of the fairest elections, and in my own opinion, in certain ways, if not for the failure to upload the results, is the outcome showed an extremely fair election. This is the first time you didn't have a landslide. You had a three-way race, 6-point-something million votes for one person, for Peter Obi, 7-point-something for Bakatiku, and then 8-point-something for the incumbent APC and Tinubu. When you look at it, almost two-thirds of people did not vote for Mr. Tinubu, but because of the system we have, he became president, having satisfied the requirements. But for the first time, we saw that the incumbent did not get the majority of lawful votes cast. He got just over a third, but enough to get him over the line. I think that's a testimony of sorts to some credibility. There were malpractices and there were voter suppression, and there were major issues with Rivers State. In Lagos State, there was voter suppression. So we don't know what the outcome would have been, whether one of the three would have scaled through. It's difficult for anybody to know. And so tomorrow, many of people claim that A or B won the election. Now, so there's need to rebuild trust, and if it can continue that trajectory, it can do very well. Edo is a good example. Just in 3 weeks' time, and next month, in November as well, they will go to Ondo. Now, if we see that, if the people begin to see that, okay, INEC can conduct a good election, then maybe there'll be hope for 2027. You have Anambra to come. You have several governorship elections to come. Apart from senatorial vacancies occurring in the National Assembly, you have major. Edo is there, Ondo is there, Ekiti is there, Osun is there, Anambra in between. So yes, at least 5 off-cycle elections. I'm not too sure whether people were happy about Kogi and Imo, even though they've been validated by the Supreme Court. But people have lost a lot of faith, not only in the electoral management body, but also in the judiciary. And we must rebuild that trust. There are no alternatives. The judiciary will be the body that will settle whatever dispute that arises from any dispute arising, whether it's from election or it's from any other thing. The judiciary is the body charged with that responsibility, and the INEC is the body charged with conduct of elections. It must earn the trust. Those institutions must earn the trust. The security agencies must also earn the trust that they will be impartial and professional. So, we must rebuild trust in the system if our democracy is to survive, is to work, and if we are to consolidate. For democratic consolidation, we have no options.
Last question. I know I said last before this one, but I probably this is going to be the last one.
That was the last in the final.
Yes, this is the final. I know you're an outsider now, but from where you stand, do you think that INEC is ready for the election in Edo State in 3 weeks?
Well, let's put it this way. INEC has been faithful to its timetable that it released quite a while back, almost a year ago. It's been faithful to that timetable. It has not missed any deadline. We are in the process of collection of PVCs now. So we are hopeful that it's ready, but sometimes you don't know until the day of the election itself. The indications, the indices are that, yes, it's getting ready. It is booked a calls for a stakeholder, Catherine, and possibly peace signing accord. So all the things are there, all the indices are there. But we'll see about the logistics. The logistics is always a challenge, in spite of the rack centers, the camps that they have for camping the staff and officials just before the elections. In some cases, they've not worked as well as they should, but they generally tend to work better in off-cycle elections. In the past, they had 92, 95%. We see no reason why we should not get 99 or 100% this time around with the job. We are hopeful that it will live up to expectations of Edoites in terms of delivering a credible election, getting logistics right, getting the process right, making sure the votes count, uploading all the results onto the Beavers, onto the iRev so that people can see it worked 4 years ago. We wouldn't expect improvements. Well, extremely well 4 years ago. We expect improvements 4 years down the line. Now technology has evolved in the last 4 years, and we expect that this new INEC, that things will be in accordance with the regulations, with the laws, and with their processes. And we hope INEC will not come and tell us one thing and another thing will be done. And that has been one of the reasons why trust has been broken in the past. When you say, yes, we'll use the beavers, yes, there'll be upload of results, and then you go to tribunal and argue that, well, that's not the law. And in fact, I think some officials even said real time. I knew that was not likely feasible, but we'll be satisfied if within minutes of scanning of those results they are uploaded, we'll be quite satisfied with that. And it's our hope, and being an ex-INEC official, I'm rooting for them and hoping they do the right thing. The consequences will be very dire if they don't do the right thing. It will not be good for democracy. It will not be good for peace and stability, not only in our state but in Nigeria as well. It's on the threat. It's as night follows the day, there are dangers ahead if they don't live up to expectations.
Is your heart going to be in your mouth on the day of the election as a former INEC official?
Well, I'll be rooting for them to do the right thing because me as an individual and my party and my government believe that we have a good candidate, that we are confident of winning a free and fair election. No, it will not be. I'll root for them. I'll give them benefit of the doubt. I'm one of the few people, not so many, who give them that benefit of the doubt. And we look forward to 21st of September when the elections will be conducted. Not just the election itself, not the process. The logistics has to be gotten right. The delivery of materials and everything else, the upload of the results, and the declaration of the results. We look forward to that. And I'll be one of the first people to pat my former colleagues on the back and say, you did a good one this time around, and we will root for you, we'll support you in every which way. We are trying to support the government as a government of Edo State. People of Edo State are supporting INEC to deliver on it, and we're hopeful. Fingers crossed for some people, but we're hopeful.
I can only join you in hoping for the very best. Thank you so very much, Mr. Uzzi, for this honor. I'm very grateful. I wish you all the very best. Thank you very much.
Thank you for having me. It's a pleasure. Thank you.